Thank you, David. I always kind of wonder why they put the attorney who's going to be going through the statutes right after you've had lunch and are just settling in for the rest of the afternoon. But I'll do my best to try to keep everybody's attention because this is an important topic that we're going to be talking about. Again, my name is Grant Claypax. I'm a partner in the law firm of Bingham Greenbaum Dahl. I've been practicing in this area for just over 20 years now. We do a lot of work with counties, cities, and towns across the state of Indiana. We have offices here in Indianapolis, as well as Evansville, Jasper, and Vincennes, as well as in that state directly to the south of us, but I better be careful because I think I may be recorded back there. But what we're going to be talking about today is public purchasing, and this is David alluded to, is a topic that, quite honestly, we could spend a couple hours on if we were so inclined to do so. I remember the first time that I was asked to give this presentation and keep it between 30 and 45 minutes, I sort of felt like those old, I think they were FedEx commercials where I was just talking as fast as I could to try to get through everything. So I think now I've got the hang of this and I can scale this down in a way that gets you what you need to know for today. But obviously, a couple things I'm going to leave you with. One of them is, in your day-to-day work, if you do have questions about this, and if you've consulted the statutes and it looks like Greek, you should always contact your county attorney. That's what he or she is there for, is to answer these type of questions, because it is important, because there are some fairly detailed statutory requirements, and you have to make sure that you're complying with that. Because when you're talking about public purchasing, and here's another one of kind of the big concepts to walk away with, the way I always think about it is you are entrusted with the taxpayer's money. You are to be acting in the taxpayer's best interest. This is you've got their money, and you've got to use it wisely, and you've got to use it in a way that if somebody comes into the office and says, I want to see why you made the decision that you did, you can show your work and justify that you did what you did. And so hopefully what I'm going to give you today are some tools that you can use to make sure that you understand, at least generally, how the process works and what you need to do to be in compliance. So we're going to be talking about three different topics, really, when we talk about purchasing. The question that you kind of have to start with is, well, what is it that I'm buying? You may be buying services, hiring an attorney, an engineer, an architect. There's one set of statutory provisions for that. You may need to build something. We've got a new project that we need to do, or we have some renovations that we need to do. How do we go about purchasing that work? How do we go about that job? Or, very commonly, you need to buy supplies. Whether that's printer paper, pens, pencils, salt, sandbags, whatever it may be, we've got to buy supplies. That's the third. So there are really kind of three different statutory schemes that we're going to be talking about, and I'm going to cover each one of them. One thing I also do want to mention, we have till 2 o'clock. If anybody here has any questions during the presentation, don't hesitate to raise your hand and ask. I'm happy to answer questions as we go along. I want to make sure that you're getting the information that you want. As we get closer toward the end of our time, if it looks like I'm going to need to get through this without taking any more questions, I may just have to skip over that. But I'll be around for a little bit afterwards, so if anybody wants to come up to me and ask any questions at the end, that's fine too. So let's start off. We're going to kind of ease into the presentation and start off with probably what I would consider to be the easiest or less complicated statute, which is purchase of services. There are really very few rules that apply, and services, as you'll see up on the screen, defined as furnishing of labor, time, or effort by a person not involving the delivery of specific supplies other than printed documents that are merely incidental to the required performance. The example that I always think of is, well, what I do for a living, for example. You're buying, people look at attorneys and say, well, what do you actually produce? What do you do? And well, you're kind of buying my knowledge and my experience and my expertise with law, and maybe I'll produce some paperwork for you. But that's what we're talking about. Attorneys, again, architects, engineers, a construction manager. That's what we're talking about in terms of services. And there's really fairly broad discretion that public bodies have when retaining service providers. Basically, as shown up there in the second bullet point, the body has the discretion to retain service providers using any procedure that the governmental body considers appropriate. So that's pretty broad and pretty loose. I guess the question always comes up is, well, what is appropriate? And you have the ability, but not the requirement, to put together rules in terms of how you will determine what is appropriate when making decisions to retain services. Again, you don't have to have rules, but you may want to have rules. Sometimes rules are good because they can provide cover, and if somebody says, well, what do you mean by appropriate? You have something you can look to and show them and say, this is what we mean by appropriate. These are the rules that we've approved and adopted that shows what's appropriate, that you can fall back on and say, you know, that gives you a little bit of cover, I suppose. If you do choose to adopt rules, though, the important thing to remember is that you can't deviate from them. You can't say, well, I don't have to adopt rules, but I did. But in this circumstance, I don't want to follow those rules, so I'm going to kind of default back to the I don't have to have rules. That doesn't work. Once you adopt rules, you've got to follow them. So that's one thing to remember in doing public purchasing of services, is that if you have rules that dictate how you're going to go about that, you do have to follow them. And again, it's really in your best interest to do so, because it does provide you with that backup that if questions ever do arise of why you did things a certain way or hired somebody instead of somebody else, you can point to that and justify the decision. There are special statutory sections that deal with architects, engineers, and land surveyors. There you can see a public owner can contract for professional services on the basis of competence and qualifications and negotiate compensation. So you don't have to just accept what they offer. You can actually negotiate down and try to get the best cost for those service providers. Or if it's a particularly complicated job and you think that it justifies paying a little bit more to get somebody who has a little greater expertise, you can do that as well. Again, you can see also up there, you have the discretion as whether you want to provide notice. You don't have to, but again, it's one of those things. If you decide that you are going to put notice out there, and sometimes you may want to put notice out there, you may want to get more than one interested service provider essentially bidding or quoting the job for you so that you can negotiate. If you do decide that you're going to put notice out there, you can see there that what has to be included. You have the location of the project, general description of the project, what the criteria are that are going to be used in selecting the architect, engineer, surveyor, what have you, where additional information about the project can be obtained, and then also your business hours and the last date that statements of qualification will be accepted. So there are special rules there that you have to be mindful of regarding architects and engineers. Construction managers also provide a service. There are some limitations in terms of using construction managers on public projects. For example, the owner can't use the same architect or engineer who designed the project to also serve as the construction manager. And just when I talk about construction manager, oftentimes what that really is, that's sort of a consultant that consults with the owner about the construction process. It's not the architect who designed it. It's not the general contractor. In fact, as you see there, construction manager can't compete for or be awarded any part of the actual work, but it's someone who more provides expertise and is a consultant and an advisor to the public body on a construction program. So there are a couple of limitations there that are specific to construction managers. There are certain types of projects that there's an exception for through 2017 that allows construction managers to hold contracts, to essentially sort of be in almost a general contractor type of role, but to contract directly with contractors doing the work. Higher educational institutions can use those until July 1 of 2017. And then, and this is going to be important because it's going to be coming up the second half of 2017, between July 1, 2017 and June 30, 2019, that can be done on all public projects except for NDOT jobs. And so something to be mindful of, that there will be a change coming up during your term here in terms of how construction managers can be hired and what they can do. Again, if you have questions about that, at the time, it's probably best to contact your county attorney and ask about that. Service provider contracts also have to include provisions. Yes, sir, in the front.
The construction managers take all the bids, right? And then they determine the low bid and
They can. They certainly can do that, is that they can accept the bids and make that decision. I mean, ultimately, it's always the agency or the board that makes the decision in terms of what's the, as we'll talk about here in a little bit, who's the most responsive and responsible lowest bidder. But certainly part of the services that a construction manager may provide is that they would basically run the bidding process, even though they wouldn't be the ones that ultimately make the decision. Yeah, absolutely, absolutely. In terms of, and we'll talk about that in a little bit, but like in terms of putting out notice for bids, there's a lot of work that does go into that, and that's where a construction manager can assist as well. Anybody else have any questions at this point? Okay, E-Verify program, that has to be included in your contract for services entered into by any state agency or political subdivision. These are certain provisions that have to be included, which includes an affidavit requiring enrollment and participation in the E-Verify program. What the E-Verify program is it's basically that you have to provide an affidavit and a certification that you aren't employing illegals as part of what your workforce that you're providing to the project. These have to be people who are legally here to work in the United States, whether as a citizen or otherwise. So in other words, you don't have any illegal labor. So that's essentially what the E-Verify program is, and you'll see that throughout as we talk today. That's going to be required whether you're purchasing services, public works, or supplies, that the E-Verify requirements are going to come into play. There's some other things that have to be included in your contracts. One, anti-discrimination provisions under 22.9.110. That applies to all contracts that are entered into by the state or any of its political or subdivisions. And it requires a provision where the contractor or vendor agrees not to discriminate on the basis of the things that we're familiar with, race, religion, national origin, age, etc. There are also provisions in the Indiana Code that you see up there that disqualify contractors who do business with the government of Iran. I'm not sure that there are a lot of them that are out there, but there is a statute that provides that those folks are disqualified. You can't hire them. So that applies for all contracts, whether it be for public works, services, or supplies. And so the contracts, in addition to the E-Verify affidavit and certification that we just talked about, they do require certification that the contractor or vendor is not engaged in any business activities with the government of Iran. So something else to be mindful of. Anybody have any questions on retaining services at this point? I say it's sort of the most open and least restrictive of the topics we're going to talk about, and if nobody has any questions at this point, we'll get more into the public works part of this, which I deal extensively with. I do a lot of work for construction projects, and that's governed under Title 36. You'll see up there 36-1-12-4. Yes, sir. You're right. We'll talk about that. And he brings up a great point. The question was, what's the dollar threshold? If you're just doing a little job, you don't have to publicly bid, and that's true. Depending on what it is, there are different levels, and this is again why it's important to understand at least kind of where the statutes are and have a general idea of what your dollar thresholds are, because You may be able to use your own forces if you've got people capable of doing the work. You may be able to just take quotes instead of do a full public bid process. And we'll talk about the different dollar thresholds that come into play. What is a public work? As you'll see up there, it's defined to be the construction, reconstruction, alteration, renovation of a public building or other structure that is paid for out of public fund or a special assessment. And that includes, for example, construction, alteration, or repair of highways, streets, alleys, bridges, sewers, etc. Basically, any improvement that's paid for out of a public fund or a special assessment, that's going to come within the scope of the Public Works Statute under Title 36. If the public work is going to be at least $150,000, the provision that comes in for public bidding applies. And I'm already going to tell you now that you're going to walk out of here saying there are exceptions to rules and exceptions to exceptions. And in a minute, we're going to talk about one of the exceptions because there is another part of the statute that says if it's for certain projects under $250,000, you may be able to avoid the public bidding and take quotes or use your own labor instead. But generally speaking, the threshold is $150,000. If your job is going to be of $150,000, it has to be publicly bid. And sort of the concept behind the public bidding, and I mean all these statutes, the case law that's out there talks about you want to prevent against fraud, corruption, graft, collusion, anything like this. Again, you want to, again, it's the concept of essentially you are the trustee holding the taxpayers' money. You've got to use that wisely, and you have to use it fairly, and you have to use it in their best interests. And so as we talk through this, that's kind of the overriding concept behind why the statutes are drafted the way that they are. To publicly bid it, you have to develop plans and specifications. You can't have plans that unduly limit competition. In other words, you can't have plans that call for something that only one provider, only one supplier gets into. I know there are certain cases out there that talk about swimming pools, and there are certain, processes for, cleaning the pools that, I'm not a swimmer, but basically keeping the, circulating the water and all that, the specs were such that only one supplier out there could comply. You can't do that. You've got to make all their specifications so they're open for competition. There has to be an invitation to bid that goes out, and the plans and specs have to be made accessible. So anyone who's an interested bidder, there's got to be a statement in the invitation for bids of where the plans and specs are on file and the times when they are available for public inspection. The notice for bids, the invitation to bids has to be published. Has to be published at least twice, at least 1 week apart. And the date between the first notice and the bid date for jobs that are under $25 million has to be no more than 6 weeks, and for over $25 million, no more than 10 weeks. So you can't put notice out there and then 6 months later is when you have your bid and it says, well, wait, I never saw that. What happened there? Now, it's got to be close enough to the bid date that it properly puts people on notice of when bids are going to be accepted. And then the second publication has to be at least 7 days before the bid date, sort of the opposite end of the spectrum. If you can't have your second notice be the day before, and somebody says, well, wait a minute, I didn't even have time to consider this job or put together a bid. So it's got to be at least a week in advance of the bid date, and the notice has to specify, again, where the plans and specs are on file, and the date, time, and place for where bids will be accepted and publicly opened. As part of accepting bids, there's a Form 96 from the State Board of Accounts that has to be included as part of the bid. And there are reasons for this, which we'll get to in a minute, that says what the bidder's basically capabilities are for performing the job. What's their some financial statement, not full financial statements, but a summary of their company finances, so you know that you're not too much at risk of the company going under, halfway through the job. Statement of experience, are they qualified to do this? Their proposed plan for doing the work, and what kind of equipment they have available. Again, this is all to make sure that, in fact, the people who are bidding on your job are capable of doing it. There also has to be included as part of the bid a non-collusion affidavit. Again, just as I said, the overriding concept is that use the statutes to prevent any kind of fraud, collusion, or injustice. You can't allow deals where you may have two contractors that seem to always be bidding against each other, and they have a handshake deal of, okay, I'll let you get this one, and the next one's going to be mine. That doesn't work. So there has to be a non-collusion affidavit. And as well as for many projects over $200,000, there is going to be a bid bond or a certified check that has to be submitted with the bid. The bid bond is not to exceed 10% of the bid. And then, importantly, once bids are received, they have to be opened and read aloud at the time and place designated in the invitation to bid. Again, that's kind of the idea there is you really want to promote public confidence in the process. That it's not as though somebody's taking these bids, going behind closed doors, and then emerging saying we've got a winner. As they're opened, you read them out loud. Everybody who's there, people, it's an open meeting. People are allowed to attend. Any interested bidders will probably have a representative there so they can hear the bids and understand, at least on the face, who the low bidder is. Now, the low bidder doesn't necessarily end the decision of who's going to be hired, but it goes a long way toward that. And I say that it doesn't end the decision right there because in addition to being the low bidder, it has to not just be the low bidder, but it has to be the lowest responsible and responsive bidder. And of course, there is also the option that you could reject all bids. If all the bids come in higher than what you've budgeted for a particular project, the board has the right to reject all bids and say, we're not going to go forward with this project at this time. Thank you very much. But if you do decide to go forward with it, you have to take the lowest responsible and responsive bidder. So, factors to determine whether or not there's a responsive bid. I mean, basically, when we're talking about responsiveness, what we mean is, did the bid that we received actually match up with the specs and plans that we put out there? If we said we wanted to that we intend to build a 3-story building and somebody's bid is the low bid because they only bid it for it to be a 2-story building, well, that's not a responsive bid. So that one gets thrown out even though it's probably the lowest one. Factors to consider: does the bid or quote conform in all material respects to the plans and specifications? You can have very minor deviations, but if it's not going to affect the scope of the work or the price significantly, that's what we mean by material respects. Does the bid comply with the invitation to bid and the instructions to bidders? Does it include, for example, everything that we just talked about in terms of the non-collusion affidavit, the State Board of Accounts form, et cetera? And then does the bid otherwise comply with applicable statutes, ordinances, regulations, or rules? So if you have special rules that have been adopted regulating the form of the bid, that's what you're looking at. So the first question, is it responsive? A little bit trickier question is the bidder responsible? And we talked about some of these other requirements that we looked at in terms of financial statements, experience. That goes to the question of whether or not they're responsible. And some of the factors you can look at are the ability of the contractor and the capacity of the contractor to perform the work. If we hire this firm, will they actually be able to get this done? And do they have the capacity to do that? The integrity, character, and reputation of the bidder. I will just tell you to be careful about this, because even though the statute provides that you can use that as a factor, if you ultimately decide not to take the lowest responsive and responsible bidder, you have to have minutes that are open for public inspection that explain why you didn't choose the low bidder. And if it's based upon there are questions about the reputation, the integrity, and the character of the bidder, you need to be very careful about what you put in those minutes. When you're talking about somebody's reputation, it really needs to be more than, well, we hired them once before and they were kind of a pain to deal with, and we'd really rather just use somebody else if we could. It really has to be a lot stronger than that. And I don't have any specific examples, unfortunately, but it's something that you need to be very careful about if you're going to make a decision based upon reputation and character. And then obviously the competence and the experience of the builder. You know, if it's somebody that's built track homes, you probably don't want to hire them to, you know, come in and build your new sewage treatment facility. They may not have the competence to take on that kind of a job, even though they're just looking for work. And those are sort of threshold terms. And it, you know, when you're talking about whether or not a bidder is responsive or responsible, I always think of it as it's a light switch. Either it's on or it's off. Either they are or they aren't. You can't look at it and say, well, you know, I think that this one bidder is a lot better than somebody else, than the low bidder, so they're more responsible. That's not how it works. Once you clear the hurdle of you're responsive and responsible, then you're looking at dollar figures at that point. And there's a case out there that you see I've cited up there, involved Bowen Engineering, where the Court of Appeals here in Indiana says the board's not been given the discretion to award a contract to the most responsible bidder. Rather, the statute just provides the board has to require that the winning bidder be responsible. So again, once you meet that threshold, you're either in or you're out. It's not that, well, one bidder is more responsible than the other, so I'm going to use that as a plus in that bidder's favor. Once you clear that threshold, then the determining factor is going to be dollars. You know, who's the low bidder among all of those who meet the threshold of being both responsive and responsible. And as I mentioned before, if you decide to award the contract to somebody other than the low bidder, you have to show your work. Again, there almost certainly going to be questions, probably from the low bidder himself, of, well, I was the low bidder and I think I'm responsive and responsible, but obviously maybe you don't think so. So show me why you made the decision you did. So you have to state in minutes or a memo at the time of the award the factors that were used in determining who the lowest responsive and responsible bidder was. And that has to be kept on file and made available for public inspection. Again, the whole idea is it's not your money, it's the taxpayer's money. And if the taxpayer has a question about why are we paying a little bit more to somebody else when we could have been doing this for less money, you've got to be able to explain what your decision is. And so the statute requires if you go with somebody other than the lowest responsive and responsible bidder, you've got to provide an explanation in writing and open for inspection about that. There are some additional requirements about public work projects. Payment and performance bonds are required if the work exceeds $200,000. If it's under $200,000, it's at the board's discretion as to whether or not a payment and performance bond are required. On public works projects in Indiana, mechanics liens don't attach. You can't file a mechanic, you know, if there's an unpaid subcontractor or supplier, they can't file a lien against public property. You just can't do it. And so to make sure that people are getting paid on the job, that's why you would have a payment bond in place. And so it may be a good idea, regardless of the size of the job, to have that bond on file, because you want to make sure that folks are actually going to get paid for the work that they do. And performance bond, if the bidder that you choose ends up not being able to complete the work, that performance bond you can look to as a source of funding to, for example, bring in another contractor, have somebody else do it. So again, regardless of whether or not you're over or under $200,000, it may be a good idea. Obviously, there are costs involved to bidders with obtaining these bonds. Those are probably going to be passed through in their bid. So if it really is a small project that you're going to be bidding, although again we'll talk about the thresholds of when you have to, you do have some discretion as to whether or not you want to require that bond. In many cases, though, it's a good idea to have them. You may have heard that in 2015, the Common Construction Wage Statute was repealed. This was in all the papers. It was kind of a big deal at the time that the Common Construction Wage was going away, and one of the concerns with that was, well, what it was in the first place was that on public works jobs, wages being paid to laborers had to hit a certain threshold, and depending on where the job was, there were different thresholds that applied in terms of kind of what was the common wage within that community. Well, that was taken away. And one of the concerns was, well, if we're not going to require that workers be paid a certain amount, how do we know that we're getting good quality workers coming and doing our jobs, because obviously now a contractor isn't bound to paying them at a certain level. And so since there's no longer a wage scale, what we now have are contractor tiers. And so in evaluating the bids that you receive, you look in terms of how they're going to actually perform the work and who they're going to have performing the work. When it talks about Tier 1 contractors, that's essentially a general contractor. I mean, who is the one who is primarily responsible for getting the job done? And the general contractor has to certify that it's going to do at least 15% of the total contract price of the work itself. So you have some confidence that they're not just subcontracting out everything, but essentially they've got some skin in the game too, that they're going to perform some of this work. If it's a Tier 1 or a Tier 2 subcontractor, Tier 2 being a subcontractor or someone who contracts with the Tier 1 contractor, if you have at least 50 workers, there has to be proof that they provide access to a training program and participate in an apprentice training program. I know last year at this time was talking to a lot of contractors in terms of, well, what do we need to do to comply with this, because it seems like another burden, but that's for the contractor, not for you. You just need to make sure the contractor's doing it. Again, we talk about contractors have to have some insurance requirements, comply with the E-Verify program, and preserve payroll records for 3 years after completion of the project. And again, that's if somebody has a question as to whether or not who is getting paid what on this, and have they complied with the statute, you have the opportunity to go back and review records. And all contractors ultimately now under the new statute have to be qualified by the public board. And so these are some of the factors that you look at in terms of whether or not they're qualified, since you can no longer look and make sure that they are paying the common construction wage. Retainage on a project, that's money that gets held back toward the end to make sure that everything gets completed at the end, all the punch list items, et cetera. You hold retainage back to give the contractor an incentive to come back and finish up all the little odds and ends, or maybe not so odds and ends that need to be done to complete a job. There's some options there that the public board has. You can either go no more than 10%, between 6 and 10% until the public work's 50% complete, and then no retainage thereafter. Or you can do 3 to 5% throughout the life of the project. If you're doing a highway, road, or street project, you don't have to have any retainage, though. That's one of the exceptions. Change order limitations. Limited to 20% of the original contract price. The purpose of that is essentially so that you can't find an end around the public bidding by issuing change orders. In other words, we're going to change the job so substantially and make it different. We're going to maybe bid something out at $150,000, and then have change orders that make it $1 million job. And once we've got the contractor we want, we just didn't want to have to bid it out. So change orders, you can't be more than 20%, because beyond that, it essentially becomes, that's a large enough change that it's essentially a new job and has to be bid out on its own. So limitations don't apply to circumstances that could not have been reasonably foreseen. So for example, if there's some natural disaster or something that significantly is going to impact the time that a job's going to take, or the cost of a job because you have to deal with certain conditions, or if there's some unforeseen conditions once you break ground, those aren't included. You get a pass for those, but you basically can't. You can't bid a job out and then basically, have so many change orders that it's something completely different than what was put out for bid. So that's why you have the 20% limitation. Now, we get into some of the thresholds. Does anybody have any questions so far in terms of how the public bid process works? Okay. For jobs, for jobs in excess of $100,000, you have to have that work done per plans and specs, approved by a licensed architect or engineer. I forgot here, there are a couple things I need to cover. Plans and specs have to be approved by the State Department of Health, et cetera. And again, 36-1-12-19 is similar to the change order restriction of you can't divide up a public work project into multiple jobs just so that you avoid the public bid process and requirements. In other words, we talked about our $150,000 threshold, and you look at it and you say, well, this is a job that's going to cost $300,000, but I really would rather not have to publicly bid it. I'd rather use some of these other options that I have at my disposal. So I'm going to turn it into 6 jobs that are $50,000 each. You can't do that. And if it's obvious that that's what you're trying to do, somebody's going to be able to challenge the award of that contract or the issuing of those contracts and probably prevail. As we'll talk about, there is pretty broad discretion that public boards are given in terms of how they award contracts and who they award contracts to, provided that they follow the statutory requirements. But courts really don't like it if they can tell that you've tried to devise some sort of scheme to get around what the statutes provide. There was a case a couple years ago, essentially, where it was a school corporation transferred a building into a trust for 48 hours, entered into a contract. As soon as the contract was entered into, the trust gave it back to the county, and that got challenged, and the court said, well, wait a minute. That, obviously, that was just a ruse to get around the public bidding, so that, you can't do that. Anybody have any questions? You just talk over there. Okay, that's fine. If they do find that you've designed it in a way to avoid the public bid requirements, a knowing violation's a Class A infraction. They're under the statutory site up on the screen. Here are some options. The owner can use its own workforce. If the public work project is $250,000 or less, and if the public owner has the ability to perform that job with its own workforce, you don't have to hire somebody who's not already a county employee. You can purchase and lease materials in the same manner that we're going to talk about in a few minutes here under Title 5-22. But again, the owner has to be able to show that it has employees on its own workforce that are capable of performing the work. In determining that $250,000 threshold, what you look at are what are going to be the costs of the materials, the labor, the equipment and rentals, reasonable rates for use of trucks and heavy equipment, construction equipment, and all other expenses incidental. If all of that adds up to $250,000 or less, then there is this option available. Any public work that is going to be performed by the public body's own workforce, though, does have to be inspected and accepted as complete in the same manner as a publicly bid contract. Yes, sir? The question is, can you split it up, as I understood, if I think I heard you correctly, can you split it up, publicly bid it, and still get contractors involved? So you can get local contractors. So what you're talking about... Oh, yeah. I mean, it's not a question of... If you're, for example, if the project is under $150,000, well, actually, let me think about that here, because what you're talking about is, can I make it into several smaller projects just so I can get local folks involved? Yes. I think you'd be subject to some questions, even though I understand that you have good intentions. If the job is really one job, and again, we go back and we talk about. Let me find where I was there. You can't divide it up into multiple projects. And you say, well, our purpose of dividing it up isn't to avoid bidding, but to get more local people involved. I suppose you technically don't run afoul of this, because the idea isn't we're not going to publicly bid it. We're still going to go through the process and take bids, right? That's your... I suppose you could have local, larger contractors that complain and say, well, wait a minute, you know, you've divided this up. I guess as a practical matter, though, the answer that the kind of the practical question you'd have to deal with is, would I want that? You know, if it's really one job where you might have one general contractor running a $300,000 job, do I really instead want 6 general contractors bumping into each other and running that job? Because again, if your question is just simply, is it legal? And if you can justify that this wasn't to avoid public bidding, and in fact we did public bidding, even at the lower threshold, it probably passes muster. But I guess the question would be, you have to think about long and hard, is that truly what you want to do? Anybody else have any other questions? Okay. It was a good question. That's the first time I've been asked that one, so you made me think today, sir, which is good. Not that I didn't think this morning, I did, but okay. And again, similar to the threshold for public bidding and the dollar amounts, you can't artificially divide up a project to get under $250,000 just so you can use your own workforce. There's some other options for small dollar projects. You see there, projects between $50,000 and $150,000. You can use, you can invite and accept quotes instead of going through public bidding. Again, there are some requirements that are in the statutes for this. Notice has to be mailed out not less than 7 days before the time fixed for receiving the quotes, so everybody has proper notice and opportunity to quote a job. Like public bids, the quotes have to be opened publicly and read aloud. And in the invitation for quotes, it's again got to describe, you know, when and where that's going to be done. If the project is under $50,000 and the owner rejects all quotes, saying, well, you know, we didn't like any of these proposals that we received, then you have to establish in writing the reasons for rejecting all the quotes. Again, you have to show your work, essentially. And the owner can then negotiate and enter into agreements in the open market without inviting any further quotes. And again, though, you have to be able to prove why it was that you rejected all the quotes that you received. And then if you get down to the level, yes, sir?
Where I read here, though, that between 50 and 150,000, you have to get quotes. So if it's under 50,000, you wouldn't have to get quotes.
If it's under $50,000, you would not have to get quotes. You would have the option to do it, though. Yeah, it's an option to do it.
You're adding a building, addition onto a building that is $40,000.
Right.
Going back up to that top one there on this page here.
Mm-hmm.
Would that have to go through the architectural and have to go through the whole state approval and all that for $40,000 addition?
For a $40,000, you wouldn't have to have an architect on it. The threshold on that is $100,000. If you have to go through the state on that to get the plans approved, yeah. Yeah. Yeah, you would have to do that. Again, see, if you get down to the level where you've got a project that's going to be $25,000 or less, you can basically just solicit quotes by telephone or fax. And again, the 7-day notice provision does not apply. So that's a lot less formal if you're getting down to that dollar threshold of $25,000 or less. If it's something that's a routine operation or maintenance, it says if the cost of routine operation, maintenance, repair of existing structures, buildings, or real property is estimated to be less than $150,000, essentially you use the procedures that are the same that we're going to talk about for buying supplies. And so, you know, janitorial work, landscaping, things like that. If it's routine operation or maintenance, you can use those provisions that we're going to talk about here in just a minute. I'm just about out of time. The declaration of emergency, there are certain situations, but it truly has to be an emergency. It can't be, oh, somebody's panicked about something or stressed out. It's really got to be something like we need to repair something very quickly. And again, the board minutes have to justify that it is in fact an emergency. I'm going to skip over that because I want to make sure that we cover purchasing of supplies. There are basically 4 ways to go about it. First is competitive bidding. It's 5-22-7. Similar to competitive bidding that we talked about for Public Works project, the award has to go to the lowest responsive and responsible bidder. There are some slight variations if you look in the statutes, but essentially it's the same. If you're over that $150,000 threshold, there's going to be competitive bidding for purchase of supplies. If there are small purchases under $150,000, you can use the quoting procedure. It's similar again to what we talked about. You invite quotes from at least 3 persons or firms, and then the award goes to the lowest responsive and responsible quoter, or again, you can reject all quotes if you need to, but again, you have to justify your reason for doing that. Request for proposals, at a certain level, the public owner can make a determination that, well, whether it's $150,000 more or less, if there's a determination made by the public board that public bidding or quotes aren't acceptable or isn't practical or advantageous, you can issue requests for proposals. Again, though, you have to justify your reasons in writing, and those have to be available for public inspection. Once you put out an RFP, when you get the proposals back, you can use price as a factor, but it's not controlling. You don't have to take the lowest price. You may want to, but you don't have to if you find that there's a better proposal overall. There's also an allowance for some discussion and negotiation, so you're not necessarily bound. Once you look at the dollar figures that come back on the proposals, there is discretion to negotiate. And again, if you choose to do it that way, there is a statutory procedure that you have to follow. So you don't have to do it that way, but if you do, then you're stuck following with that. Special purchases, basically you can avoid all the procurement procedures under special purchases. What qualifies as a special purchase? Again, an emergency. Sandbags is always an example that comes to mind. If there's a substantial savings or unique opportunity, basically a liquidation or going out of business where you have an opportunity to get supplies at a heavily discounted price. Auctions, or if there's a single source of supply, basically there's only one supplier that we can get this from, then you can make a declaration that we're going to use the special purchase procedures. If you don't receive any other offer, any other procedures that we've talked about, the other 3, if nobody else is interested, then you can go out in the marketplace too, et cetera, et cetera. So again, if you have questions, and I'm sorry that I feel like I'm skipping, and now I'm at the point where I'm just talking fast, and I apologize for that, but I want to make sure at least that we get through the very basics of this, and if people have questions afterward, I'll stick around, and feel free to come and ask me or again, ask your county attorney. There are opportunities to purchase under state QPAs or quantity purchase agreements. Essentially, if you can get online there, as you see on the Department of Administration on their website, they have a list of contracts that come under the QPA program. And essentially, the local county has the benefit of the deal that the state has negotiated and entered into, as long as the state has also made sure that it has complied with all of its statutory requirements, then that may be an option too. So maybe something that you want to at least compare and consider as another option in making purchases. If it's something that the state also has a contract for, you may be entitled to those terms. What's that? No, you can do it again as long as you follow the statutory procedure there outlined, and if the state has complied with the procurement laws when it entered into the QPA, then it can be available to you because it requires the vendor to make them available to political subdivisions under those same terms and conditions. There's some miscellaneous provisions in terms of purchasing preferences. For example, there are certain things that have to be manufactured in the United States, such as steel. There are other preferences. For example, if a neighboring state or another state has a preference statute that discriminates against an Indiana supplier, in other words, gives, if the state of Illinois, I don't know if they do or not, but if the state of Illinois has a statute that essentially gives a preference to an Illinois supplier, and then they bid on providing supplies in Indiana, basically you can use the reciprocal. You're entitled to use their statute against them and give a preference to the Indiana supplier. So basically what's good for the goose is good for the gander. If you're going to discriminate against Hoosiers, we're going to turn around and discriminate against you. It doesn't happen very often, but it is on the books. Again, there are several other preferences, smaller preferences in terms of, for suppliers with goods made in the state of Indiana. You should consult the statute or consult your local attorneys about that. Kind of the same factors in doing purchasing of supplies in terms of, are they responsive and responsible? Again, apply as we talked about in the public work process. And if there is a determination in terms of bids for providing supplies that you're not going with the low bidder or quoter, you've got to make that determination in writing and open for inspection to provide an explanation of why you made the decision that you did. And that goes for responsiveness as well. Again, like public purchasing and public works projects, as part of the submission, there have to be documents that evidence financial responsibility, bonds, et cetera. There also have to be affirmations, again, that provide that you're not colluding or making an offer in reference to any other offer, et cetera. So I feel like I skipped through that last part fairly quickly, but again, if anybody has questions, I will stick around for a little bit here. You can catch me out in the lobby. Otherwise, I appreciate your questions. Those of you who asked questions, they were great, and I appreciate your attention this afternoon.